Oral contract. Generally, an oral contract for a sale of land is prohibited and is not enforceable. However, if there is sufficient evidence of past performance, the Court of Equity, considering circumstances, will decree specific performance. International Textile Industries Nigeria Limited and Aderemi, 1999, 8 Nigerian Regular Report, Part 614 at 268. This occurs notwithstanding that the oral agreement is in breach of the Statutes of Fraud Act 1677 and Section 5 sub 2 of the Law Reform Contract Act. Adeniro and Olagunju, 2002, Federation Weekly Law Report, Part 87, page 825 and 839. Oral contract for a sale of land is a common method of acquiring land under native land custom. To this effect, a written document may not be required. The minimum requirements for such a contract for sale of land are: 1. The purchase price must be paid. 2. The purchaser must have taken possession. 3. There must be witnesses present during the transaction. 4. The land must be specifically identifiable. Open contract. This is a contract for a sale of land which is neither an oral contract nor a formal one. It provides for the barest minimum requirement under the Statutes of Fraud Act 1677. Here you have the parties, the property, the price, and the signature. There is also a memorandum signed by the vendor. In Kachala and Banki 2006 JLR 47383SC, it was held that a simple receipt issued to the purchaser by the vendor may also serve as evidence of such note or memorandum. Also in the case of Jukma and Grovio Bay 1967 LCN 1487SC. One of the disadvantages is that the terms are not stated. Formal contract. This is a standard contract which, apart from meeting the requirement as to the parties' property, price, and signature, goes further to include other special terms agreed to by the parties. Special conditions in a formal contract of sale. Deposit. This is not a mandatory requirement, but it is expedient. The payment of deposit is a sign of evidence of commitment on the part of the purchaser, and it binds the vendor, who cannot sell the property to another person unless there is a breach by the purchaser. It is better that a deposit be paid to the vendor's solicitor, who would hold same as a stakeholder. Very important, deposit is different from part payment and is non-refundable in the event of default by the purchaser. For part payment, the parties have agreed on the contract already, and payment is a portion of the purchase price. Take note that it is always important to pay the balance of the purchase price at the agreed stipulated time. Odusoga and Ricketts, 2007, 16 Nigerian Law Report, Part 1061, page 554. Balance and interest on unpaid balance. The balance of the purchase price should be paid on the completion of the contract. The parties may also agree on the time for the payment of the balance and the interest to be charged in the event of a delay. At common law, the interest is usually fixed at 4%, but it is advisable that the parties should avoid their minds to the prevailing bank interest rates. Capacity of the vendor. The contract should expressly state the capacity in which the vendor is conveying the interest. The vendor may convey as beneficial owner, mortgagee, trustee, personal representative, or an assentee. The vendor must also have the legal capacity to convey, thus it should not be a minor, insane, or a lunatic. The capacity of the vendor will determine the terms to be implied in the contract. Covenants to be implied when conveying as beneficial owner. 1. The vendor has the right to convey. 2. The vendor grants quiet possession to the purchaser. 3. That the property being conveyed is free from encumbrances. And 4. That the vendor agrees to indemnify the purchaser in the event of claim by other claimants in that property. When the contract is a lease, there are 3 additional covenants. 5. That the contract is a lease. 6. That the lease is valid and subsisting. And 7. That the rents have been paid and the covenants have been observed. Chattels, fixtures, and fittings. Chattels or fittings are personal properties which are usually movable. Fixtures are fixed to the land, they almost form part of the land, hence the principle whatsoever are fixed to the land belongs to the land. Where a separate amount is agreed for fixtures, then the amount will not be included in the instrument. One of the benefits of transferring fittings at the contract stage is that the purchaser is relieved from paying heavy stamp duties. The fixtures are usually included in a schedule to the contract. Date of completion. Generally, time is not of essence at the contract stage, but completion must be within a reasonable time. It is advised to be within 3 months to avoid uncertainties. However, where time is made essential to the completion of the contract, failure to complete the contract may lead to a rescission of the contract, except where the vendor ratifies the delay. Vacant possession. There is an implied obligation on the vendor to deliver possession of a vacant property on the completion of the sale. This means that the vendor is to convey property free from any claim of right to possession by a third party. This conveyance can only be displaced if an express provision is made to that effect in the contract. Possession before completion. Generally, possession goes hand in hand with legal ownership, thus the purchaser is not entitled to possession until completion of sale. However, where it is agreed, the vendor may bring the purchaser in as a licensor or as a tenant at will. This fact must be stated in the contract to avoid difficulties in evicting the purchaser in the event of failure of the contract. Odutola and Paper Sack Nigeria Limited 2007 of edition weekly report 1214 at 1218, where the purchaser has taken possession and is aware of the defect in the title of the property, he cannot complain because it is deemed that he has waived his right. Insurance pending completion. The law is that risk passes to the purchaser immediately after the contract is exchanged. Thus, the purchaser is advised to insure the property. Castling and Preston, Section 72 Property and Conveyancing Law and Section 67 Sub 1 Insurance Decree 1977. Where the vendor insures the property in his name, he has the right to collect the money paid upon any damage to the property and can use it as he wishes. The purchaser cannot compel the vendor to use the money collected to reinstate the property. Reina and Preston, 1883 11 QBD 380. Advantages of a formal contract. 1. Contract of sale gives the purchaser time within which he can investigate the vendor's title before the actual conveyance. 2. It ensures certainty of the terms of the sale, and it crystallizes the position of the parties at an early stage. And 3. Parties are bound by the terms. There is no last minute withdrawal without being liable for breach.